Hey guys, welcome to Hughes History. In this lecture, we're going to take a look at a law passed in 1996 called the AEDPA, or the Anti-Terrorism and Effective Death Penalty Act of 1996. Now, if you've been watching the Netflix series, The Making of a Murderer, you know probably more about habeas corpus than the average person walking down the street. Or if you've watched any of my videos on habeas corpus, you probably know what it means. But nevertheless, what this law is specifically going to do, make it much harder for defendants that are convicted of state crimes, sometimes under very unconstitutional scenarios, from appealing those cases and having those convictions overturned. So let's unravel the mystery of the making of a murderer and find out why it's really hard for somebody who might be innocent of a crime, which might be debatable, of getting out of jail. Ever. Here we go. Giddy up for the learning. So a very basic understanding of habeas corpus means basically this, and it was enacted through the Judiciary Act of 1789 as something that the federal courts gave themselves the role of looking after. And basically it derives itself from English common law, but basically it means that you have certain unalienable rights, and if they're violated, that just shouldn't be. So in the Judiciary Act of 1789, the federal courts gave itself the jurisdiction of looking after citizens' rights in terms of their habeas corpus. So if you were in a federal scenario and your rights were being violated, you could appeal that decision based on these constitutional violations, whether that be the Fourth Amendment and search and seizure, or the right to counsel, or pretty much any of those individual liberties that you find in the original Bill of Rights. Now, of course, because we have a system of federalism, those habeas corpus protections were limited to the federal court system. But that's going to change in the Reconstruction era. Now, a couple of things happened. The 14th Amendment is going to be the big mama, and you can watch my other 14th Amendment videos. But the basic language that shifts this is no state shall deny its citizens due process. And if that occurs, the federal courts are going to be able to overlook that, and that's specifically put into the language of the Habeas Corpus Act of 1867. And this is not just to protect African American freed slaves, but all citizens who might be seeing their constitutional rights being violated at the state level. Now, there's a lot of people that see this as a violation of federalism, that this isn't what the original, intention of the Constitution was. But nevertheless, we have that language in the Constitution in the 14th Amendment. So it is a major reframing of the role of federalism, no matter which side of the fence that you are on. People that defend this idea to this day, even if you're seeing the original intention being for freed, slaves and their rights, is that there are problems in states when it comes to constitutional rights and who should be the best entity to look over those rights. You do have judges at the local level, on the state level. If you watch the Wisconsin drama of The Making of a Murderer, there's a lot of politics that goes on. A lot of these judges are elected, and it's very hard to run on a platform of not being tough on criminals. So in many cases, sometimes it's seen that these judicial decisions are more political decisions than they might be constitutional decisions. So throughout the 20th century, we see kind of a spreading of this idea of habeas corpus at the federal level through a number of court cases. These are called Selective Incorporation court cases, but the biggest ones occur in the 1960s under Earl Warren, Mapp versus Ohio and Gideon versus Wainwright, Miranda versus Arizona, Escobedo versus Illinois, where basically the Supreme Court, in a sense, is creating new law through these decisions, and that decisions through stare decisis are being followed by all of the courts in the land. So we have new rules being made up that you have to read suspects' rights, that you have to throw out evidence that it's been attained illegally, that if a suspect asks for the lawyer, anything that comes after that without a lawyer can't be used in a court. So the federal courts are throwing out state convictions and, in a sense, giving inmates new trials because their constitutional rights were violated. Now, this shift from the Warren Court is going to be slow and steady. It's going to begin in the 1970s under the Berger Court, and then later in the Rehnquist Court, where they're really going to put a cap on some of these rules in terms of how the federal appeal system is going to work, and we're going to start sliding towards more of a states' rights advocate perspective. Basically, these courts do three big things. Number one, they say if the issue wasn't brought up in state court, it can't be brought up in the federal court system. We're not going to have more evidentiary hearings at the federal level. Once it's done in the state, it is cooked and it comes to the federal government as is. Number two, they're going to say this search and seizure thing is going to have to stop, and they actually bar any more federal courts from releasing or giving new trials to suspects that are convicted on evidence where there's a question of the constitutionality of of search and seizure. And the final straw for at least those courts is going to be that they're going to severely limit the ability of people to come to the federal court system and say, the state's got it wrong. There's going to be a presumption that the state knows what it's doing. We're going to trust the state on the facts, and we're only going to deal with these kind of extraordinary constitutional issues. And if the state got the facts wrong, that's for the state to kind of fix by itself. Now, we've talked a lot about the writ of habeas corpus. It was known as the Great Writ of Liberty because this was the branch that you could grab onto in the Constitution, even if you didn't have any political power, if the odds were stacked against you, and you really thought that your liberty was done in injustice. Well, most lawyers would today say that this new law, the AEDPA, or the Anti-Terrorism and Effective Death Penalty Act of 1996, really puts a dagger through the heart of the Great Writ of Liberty. So now, in understanding what the Anti-Terrorism and Effective Death Penalty Act does, you really have to see kind of the context of how it was passed, because it might not do exactly what people thought it was supposed to do. Now, we just had the Oklahoma City bombing, and there was a great rush to find justice for the victims of that bombing. Whether it was done on purpose or not, Newt Gingrich and Bill Clinton specifically really attached this bill, and the wording of it, the wording starts with anti-terrorism. We just had a terrorist attack, of really looking at this law as a way to limit what was seen as kind of the endless and timeless appeals that people that were guilty, clearly guilty of a crime, could kind of make their way through the appellate process where they could go on for 10 or 15 or 20 years. So the concept was sold that this bill would put the brakes on all of that. Now, most historians believe that Bill Clinton knew better, that Bill Clinton knew that this really wasn't going to affect terrorism cases, but it was going to affect the civil liberties of every single prisoner who felt that they had some type of constitutional claim in terms of due process in the nation. And that's exactly what's going to happen through Supreme Court interpretation. But let's look at the two big boys, that's four, the two big boys of this law. Number one, it basically said that you can't just reverse something because the state's got it wrong. That if the state made a mistake, but it was a reasonable interpretation, that they weren't really trying to get somebody, but let's say that somebody had asked for a lawyer, and then another cop came in, didn't know they asked for a lawyer, so kept questioning the suspect slipped up and said something that, that probably should be thrown out because they asked for a lawyer, but the court at the state level might have interpreted that to be just a boo-boo, so they're going to keep that confession, either way. So if it goes to the federal court can't reverse that if it was a reasonable interpretation with the facts in front of those police officers. So that's number one. So basically it says a mistake isn't enough. It has to be an unreasonable mistake. And then number two, it says that you can't at the federal appellate level anymore overturn a decision or give a suspect a new trial unless it is clear as day Supreme Court precedent. So if any of the facts aren't similar in any way to a former Supreme Court precedent, the federal court's going to no longer be able to make new law, and a lot of people think this is a good idea. They're going to have to stick to the original, stare decisis decisions that came down in these former cases like Mapp versus Ohio or Miranda versus Arizona. So those are the two pinpoints that a lot of people, and when they rushed this bill through Congress, it was put on fast-track legislation. There were no hearings, no experts from Habeas Corpus testified. They just made it into a beautiful signing ceremony and signed it, and we all kind of forgot about it for a little while. But the very real effect is that thousands and thousands of cases where previously those people would have had another shot at Habeas Corpus at the federal level aren't going to have that shot anymore. But of course, the devil's in the details, and really the devil's in how is the Supreme Court going to interpret this? Are they going to interpret it loosely, or are they really going to interpret this thing to the letter of the law and put the brakes on habeas corpus completely? And if you watch Making of the Murderer, you know the answer already. Let's take a look at a couple of Supreme Court cases, and we'll try to wrap this bad boy up.
Lockyer versus Andrade.
2003. This was a court case that looked at constitutionality, specifically the Eighth Amendment, cruel and unusual punishment. and the 3 strikes and you're out law in California. Now, this defendant had been convicted on, I think, his 3rd time of shoplifting some CDs. He stole like $143 worth of tapes, and they sentenced the guy to like 50 years because of this new law in California that didn't give judges discretion. It was a law and order kind of law. Now, the Supreme Court, looking at this, was looking at former, precedent, and the new rule is you can't make up new precedent. So the specific precedent said that it would have to be gross disproportionality in the sentencing. So they said that California, because of the Anti-Terrorism and Effective Death Penalty Act, they're the ones that interpreted it. And that even if it was a misinterpretation, who's the court to say it was a gross misinterpretation? So that man who stole $50 worth of tapes is still in prison to this day. Let's fast forward 3 years, and we have Carey versus Musladen. And in this court case, the defendant who was being charged for murder, the victims' families were wearing buttons, kind of remembrance buttons, right in front of the jury with the victim's picture on it the whole time. And his lawyer asked that they be, take the buttons off because there was Supreme Court precedent that basically said that you couldn't tamper the jury with bias by having emotional tugs to them by things going on in the courtroom. The Supreme Court rejected that, saying that because in the previous precedent, the person who was wearing it or giving some type of instructions of emotion was a state officer. And because these were family members, that it was interpretable of whether or not that was a violation of this man's rights, so we defer to the state. In 2011, we have Harrington versus Richter, which was basically a case where the defendant was claiming ineffective counsel. And basically what the court said that even though there was all of this evidence that his lawyer had failed to provide, blood samples and really give a lot of evidence that wasn't turned over. And basically the court said that unless it was an extreme malfunction of the system or that the evidence presented would just be completely flabbergasting to a fair jurist, that they wouldn't be able to overturn. And considering these decisions were written already at the state appellate, level, basically the court would have to find that a state judicial appellate judge was an unfair jurist, and that just doesn't happen very much. It actually happened in The Making of a Murderer before it went to the full
7th
Circuit in Chicago, and it got overturned. If you don't know what I'm talking about, watch the movie. And if you've watched that movie, you've seen in the case of Brandon Massey, where even though you have clear violations, not only of what it looks like an involuntary confession or a false confession, but you have Brady violations where certain evidence was being hidden from lawyers. One of them was one of the main people they are accusing the crime had extreme violent pornography on their computer. And the courts have said that's for the state to deal out. If the state feels it was done constitutionally, then we're not going to overturn that. So right now, the position of habeas corpus is not a very good one if you're in prison and you're looking for the federal courts for relief. Now, a lot of people, like I said, are perfectly fine for this, that's the original intention of the Constitution, that if judges are making mistakes, they should get voted out. But there are a lot of civil libertarians that believe that there's a huge hole in habeas corpus in the nation right now that needs a fixing. But fixing rights for those accused of horrendous crimes that have been found guilty isn't a very popular position in the United States of America. So what do you think, guys? Leave your comments down below. Do you think I'm kooky? Do you think I was fair and balanced? I don't know. We try our best. We're trying to be Johnny Cash. We try to walk the line. And we try to teach all of you out there that no matter what, where your attention goes, your energy flows. If you haven't checked out the website, it's www.hiphughes.com. If you haven't subscribed, I don't even know why you're looking at me. I'm going to look over there for the rest of the lecture right now. All right, my friends, there you go. We'll see you next time that you press my buttons. We hope your brain's a little bit bigger.